the Bill of Rights is a listing of some rights, because not all of them are listed. The Ninth Amendment tells us that there are many which they haven't bothered to list for one reason or another. And it's a restriction with respect to particular rights. Particular restrictions are laid out. Congress shall make no law, right, establishing religion, so forth and so on. The right of the people to keep and bear arms shall not be infringed, right? The due process rights in the Fifth Amendment against coerced testimony and so forth. So they're spelled out in some instances. Why are they there? Well, because at the time the Constitution was being ratified, there were essentially two schools of thought. There were people who were called the Federalists, came to be called the Federalists, who wanted some kind of centralized government. And there were the Anti-Federalists, who might have been willing to go along with some kind of centralized government, but were very suspicious of the kind of centralized government that was being proposed. And the Anti-Federalists and the Federalists essentially made a political deal. The Anti-Federalists said, all right, we'll go along with ratifying this Constitution if, within a reasonable length of time, a Bill of Rights is adopted so that we are secure in knowing that these particular rights that we consider to be most important will not come under the control of this new government that we're creating. Now, Alexander Hamilton, who was a centralist and a Federalist, made a good point in the Federalist number 84, if you go read that. He said, because he was opposed to a Bill of Rights, being a centralist, of course, he was opposed to a Bill of Rights. But what he says in that particular number of the Federalists makes a certain amount of sense. He says, look, as soon as you put in a Bill of Rights, you are implicitly admitting that this original document may have granted powers to override or contradict or take away those rights.
Say that again?
As soon as you have put in this Bill of Rights, you are admitting that the original Constitution may have had powers in it that were sufficient to override these rights. As soon as you put in a Bill of Rights that says Congress shall make no law establishing religion, you're implicitly suggesting that maybe Congress did have a power originally to establish a religion. Otherwise, why would you need this thing, right? So this is dangerous because it makes suggestions which people who are trying to gain power will use. They'll say, aha! And they'll also say, you've left some out. If you have a list of 20, what about this 21st one? Well, it isn't there, so I guess we're entitled to override that right. All right? And you see, that's precisely what has happened. Alexander Hamilton, in that particular, has been proven correct in the sense that what we see today in the judiciary, at least, is an idea that, well, essentially Congress has whatever powers it wants to have unless something in the Bill of Rights precludes it. As opposed to the concept of the Ninth Amendment and the Tenth Amendment, which says, wait a minute, they have only the powers that are delegated to them, and everything else is over here, left with the states and the people. It's not just this list of the first 8 amendments, but the Ninth and the Tenth tell us there's a whole body of other things. So Hamilton, as a practical matter, has been proven right. He understood the logic of power seekers, that that's what they do. And he makes a good point. He says, you know, the Constitution, if it's read correctly, is a Bill of Rights itself, because of the limitations it puts on Congress. And I give you just one example. Let's take the Second Amendment, and let's take the powers of Congress over the militia. Because Congress has certain powers with respect to the militia, which were put there so we could have uniformity. And one of them is the power of Congress to provide for organizing, arming, and disciplining the militia. Let's just take the one arming. Power to provide for arming the militia. Well, if we look back historically at what that power entailed, what that meant, it was that everyone was supposed to have a gun. So if Congress was arming the militia according to the constitutional pattern pre-Second Amendment, Congress had the authority and the duty to make sure that every American from 15 to 50 or 60 or whatever that age group was had a gun. And what kind of a gun? A military-grade firearm, all right? Now, I would think that that's a pretty good right established right there in the Constitution. In a sense, it goes further even than the Second Amendment does, right? Because it's an injunction against Congress directly do this, provide for this, right? And if we look at what goes on in gun control today, what do we see? Well, the only kind of judicial intervention is through the Second Amendment. They don't even go back and point out that it's Congress's responsibility not to pass laws disarming people, but to pass laws providing them with firearms. So if you just look at that one, Hamilton was exactly correct. If we really looked at this Constitution and what Congress was required to do in that particular, we wouldn't even need a Second Amendment.